Good afternoon, everybody. I am Jérémie Labbé. I am Research Fellow for Humanitarian Affairs at the International Peace Institute, and I am very glad to welcome you to this discussion today, entitled, "Is Humanitarian Law Still Fit for Purpose? Implications for Protection and Humanitarian Effectiveness." This event is co-organized with the International Medical Organization, Médecins Sans Frontières, also known as MSF, Doctors Without Borders. And the purpose, or let's say this event is organized on the occasion of the publication of the release in the US of the third edition of this book, written by Françoise Bouchet-Saulnier, who's sitting on my right-hand side, which is indeed the third edition of the practical guide to humanitarian law. As you can see, it's quite a thick book. It's actually a dictionary of international humanitarian law. Indeed, the French title, and correct me if I'm wrong, but the French title is literally the practical dictionary for humanitarian law. And I'm very glad to have this discussion today around the release of this book, particularly because, and I will share here a personal anecdote, when I was a student in international humanitarian law, in international law in general, more than 10 years back now, this was indeed the French edition, one of the books that accompanied me in my studies. So I'm very glad to have the author of this book today on the table, together with our co-speakers that I will introduce in a few minutes. So the purpose of this discussion is to address a startling paradox. International humanitarian law is the most widely accepted body of international law. The Geneva Conventions, which are of the 1949 Geneva Conventions, which are the cornerstone of modern international humanitarian law, are virtually universally accepted by each single state. And besides, the international humanitarian law was considerably developed and strengthened in the last 2 decades with the development of international criminal jurisdictions and international criminal law. Yet, from Central African Republic to South Sudan, from Colombia to Syria, international humanitarian law remains widely disregarded, and civilians continue to bear the brunt of violence. This was echoed in the November 2013 report of the Secretary General on protection of civilians, which stated that, and I quote, "the current state of the protection of civilians leaves little room for optimism." So this paradox that I just mentioned raised the following questions. Has humanitarian law become obsolete or unadapted to today's conflicts due to the changing nature of warfare and of the actors of violence? And if not, has it become maybe too loose or too complex a legal framework to be applied by warring parties in today's conflict? So our panelists today will attempt to provide some reflections and some elements of answers to these questions with one objective in mind: to promote greater compliance with international humanitarian law for a better protection of civilians and for improved humanitarian effectiveness in situations of conflict. And so we would like this discussion not to be too much of a very legalistic discussion about international humanitarian law, but to come down to the practical implications this has on humanitarian effectiveness and on the protection of civilians. So I will give the floor shortly to our panelists for 7 to 8 minutes presentation before opening the floor to our audience for a Q&A session. But before that, I will quickly introduce our different panelists. You have a full biography of each of them in your paper, so I will just give you some highlights. We'll start with Françoise Bouchet-Saulnier, the author of this book, who is also legal director of MSF, Doctors Without Borders, and she has been involved with MSF for the last 20 years, right, in a variety of position, and she also currently teaches at the Paris Institute of Political Studies as well as at the Paris Catholic Institute. The Paris Institute of Political Studies is better known as Sciences Po, right? Then Hansjoerg Strohmeyer will speak next. I think Hansjoerg deserves little introduction in this community. Most of you know him. Hansjoerg has joined OCHA in December 1998. You have been the chief of OCHA's Policy Development and Studies branch since 2007. But before joining OCHA in 98, you joined the United Nations in 96, and then during 2 years, you worked on the war crimes portfolio within the UN, within the Office of the High Representative in Sarajevo in Bosnia, which, and you also have this legal background. You've been a judge as well, a trial judge in Germany during 5 years before joining the United Nations. So that's for the legal credentials of Hansjoerg. And finally, Gabor, Rona, who is the International Legal Director of Human Rights First, will share the perspectives also of a human rights organization on our subject today. So Gabor advises Human Rights First on programs on questions of international law and coordinates also international human rights litigation. Before joining Human Rights First, Gabor has worked several years as legal advisor in the legal division of the International Committee of the Red Cross, which is in Geneva, the ICRC being widely seen as the guardian of international humanitarian law. And back then, he focused mostly on the application of international humanitarian law and human rights law in the context of counterterrorism policies and practices. So with this brief introduction, I will now give the floor to Françoise. Françoise, the floor is yours.
Thank you very much. I'm very happy to be here today with you. I thank the organizer, the panelists, and all of you to have taken time for meeting together today and to exchange on the evolution of international humanitarian law, the legal framework of humanitarian action, and to figure out whether or not we have taken, some lesson from the past, because it's at the end of the day all what matters. First, forgive my English, and I hope that despite the language, we'll get to understand each other and to communicate as much as possible. Médecins Sans Frontières is not known as a legalistic organization. Our expertise is humanitarian action, and since more than 20 years for me, I am part of the daily running of the operation, the humanitarian operation in the field, and we have felt since many years the necessity to develop an expertise, a humanitarian expertise, action-oriented expertise in humanitarian law, because it's too easy to say that humanitarian law is not respected in the field, while humanitarian actors don't know about it, don't advocate about it, don't negotiate what they are entitled to. And when they leave, in fact, the military or state expertise and interpretation of the law leave alone in the situation where we must engage with all armed actors, be they governmental or non-governmental. So I'm very pleased to present this new edition that has been translated in many languages, and it's a tool for the operation. It's really a tool in all MSF mission in the field, but also for others. And as you see, this edition is bigger than the previous one. In fact, if I take all what I erased, I ended up with 350 additional pages. So, it should not lead us to the conclusion that IHL has developed or improved. I mean that if the book is bigger, it's because IHL has been challenged and contested up to its roots in the last 10 years. This is why I really was presented with a choice either to get rid of it, forget about IHL, just do our humanitarian business, or try to take up the challenge to restore a coherent interpretation of this law for the sake of humanitarian activities, for the sake of providing assistance and protection to the victim of conflict, which has developed in the last years. So, in fact, this challenge and contest of international law has been finally, I would say, restored in the last years by various court decision, also customary law, soft law, doctrine. So we've been very far destroying humanitarian law, and there's been slow restoration of its content in the past years. And in fact, there's been a lot of legal argumentation, a lot of legal debate that made this law very complex today. And I thought it was really necessary to summarize and present those legal arguments, those legal debates that have challenged the application of humanitarian law, because humanitarian practitioners in the field are confronted with this argument. They are confronted with the contest, and they must be empowered to deal with this debate in order to negotiate and fulfill their humanitarian activities. So everything was simple before, not respected, but simple. The law was simple, the situation were complex. Now the situation are still complex, but the law has become so complex that even a lawyer, and I'm not that bad lawyer, I'm even a judge, by the way, are really having very hard time to the very basic things. Define a conflict. Central African Republic, is it a conflict? Syria, is it a conflict? What kind of conflict? What is a civilian? What is a combatant? This can take years to lawyers to debate that. While, what are we applying in the field meanwhile? So it was really a challenge for me, and I think it is a challenge for all of us to decide to get back to basics and to make this law applicable. This has to be a decision. And I would say, in a rather provocative way, IHL is too important to be left to lawyers since the very beginning. It must be maintained and restored as a tool for relief work, carrying life-saving activities. So it must remain easy to understand and easy to use, both for humanitarian workers, which is obvious, as well as for the various type of army or armed groups. I mean, they don't have whole lawyers at field level, at checkpoint. So we need to be able to understand each other with the common languages, which is not that complex. So I think there's been three main trends that I tried to cover in the book that may characterize the recent IHL evolution. Why? The first one is the one I mentioned already, has been weakened by the contest. Main contest is the war against terror. I think many things have been said and written about it, but the law and the doctrine about the global war on terror are dramatically weakened international humanitarian law. Then another trend, very important, is that IHL has been upheld by criminal court. The emergence of international criminal court and the whole idea of sanction for grave breaches and crime against humanity, war crimes, has enabled judges to have their say about this law. And this has been very useful, although I will comment on it later on. It is also dangerous. And the third big trend is that IHL has been supplemented by the strength of humanitarian practice, because while everyone is debating about humanitarian law, some actors, a number of them, a huge number of them, are in fact acting in the field, giving life to this law through custom, through action. And the fact that international humanitarian law has a customary dimension has been recognized and acknowledged by the publication in 2005 of the 161 rules of international customary law, humanitarian law, that has really restored this trend of a law that is devoted to action and made alive by action and through humanitarian action. So a comment on IHL challenged and contested up to its roots by the war on terror. This is why I say that after that, there's no more definition of conflict, no more definition of combatant, and obviously no more definition of civilian, because when you choose target one, you destroy the others. No more definition of an acceptance of what was the fundamental guarantee, namely about detention So the whole trick about the war on terror was to, in fact, create a third type of conflict. Everything was new. So the idea of a third type of conflict, a third type of combatant or civilian, a third type of everything has really destroyed the very fundamental mechanism of humanitarian law that was, in fact, relying on the simple mechanism, which is definition are mutually exclusive. You are either this or that. You cannot be something else. So you're either a combatant or a civilian. There are a level and then subcategory within the combatant category and within the civilian category, but you cannot be something else. In the conflict, again, the same thing. There are international harm conflict and non-international harm conflict. The very word means that they are defined per opposition. There's nothing like a third category of conflict that will be, in fact, covered by nothing. No rules would apply because they are out of the scope of. So this was the very, very important trick used to get rid and to really shuffle the whole system. So advocating the complexity of the law and of the situation has been used, in fact, intentionally to create legal black holes. So this is something that must be clearly denounced and clearly addressed. And this has been done partially by courts, by doctrine, and so on. But what remains in the mind of everyone is that things are complex today, and humanitarian law is not applicable and does not apply and is not respected, which is not the core issue. Another thing that's very important is while we were, in fact, losing grounds of every single definition and body of law, we were pretending to regain things in front of criminal court. Humanitarian law would apply because we would sanction, punish, judge the criminals. This is a good news in a way because it has really created the sense that there are consequences if you violate this law. Fine. But there is a bias, and the bias is in the criminal jurisprudence. For the very reason that criminal law is a special body of law that abide to strict criteria and strict rule of interpretation, which is usual in criminal law, while humanitarian law is designed for wide interpretation, because as I explained, it is each category being mutually exclusive. Everything must be covered, and the rule of interpretation for international humanitarian law are very broad. It's analogy, good faith, the spirit of convention, so nothing at all to do with criminal principles. And there is real danger in relying too much on International Criminal Court decision to feed the interpretation of IHL, because it has really more fed the lawyers, very happy to deal with hundreds of pages of judgment that make this law sounds real, while in fact it tear it apart from its real meaning and way of interpretation. In the same way, criminal justice and criminalization of conflict has weighted on humanitarian action because it creates the idea that one can impose humanitarian action under threat of sanction, under threat of military presence, under threat of whatever. While the first purpose of IHL is to encourage the restraint in the use of force and to encourage negotiation in the field between humanitarian relief organizations and all type of harm groups. So this dialogue, this negotiation, this acceptance of the civilian and humanitarian nature, intention of action of the humanitarian organization is the real strength and resort of humanitarian organization. And the problem is really when you start to say that, in fact, you have to discriminate whether or not the party to the conflict is a governmental one or is a non-state, meaning a criminal, a terrorist, facing sanction by the international community. Humanitarian organizations have to negotiate with all parties. And we, in MSF, every day we negotiate with terrorists, with criminals, because this is the only way to get implementation of international humanitarian law. And we have to make clear and to be aware and to stress the danger of this criminalization of international politics, because you put the blame of people. It's fine if you are sure to win, but during conflict, you have to deal with the people in power, in charge of. And this is the only strength of humanitarian law, to transfer and to equal responsibility with force. I mean, if you are in control, whoever you are, however criminal you are, you have responsibility. And this duty of humanitarian organization to negotiate with criminal must not be blocked by international community, global management of crisis that try to put pressure, put sanction, fight against impunity, and in fact, really creating too much burden on this. You cannot get everything at the same time. The one thing about customary law, and I think I mentioned it, so I will go very quickly about it, is that this customary humanitarian law has really been a great achievement in the last years, because it has given really flesh to humanitarian law, specifically in non-international harm conflict, where the body of law was quite small. We had only Article 3 Common and Protocol 2, and the 161 rules that have been in fact, designed as customary, broadly apply the same way in non-international harm conflict and international harm conflict. So there has been a unification and a strengthening of the available rules in non-international harm conflict that must really be underlined. They are not, I mean, they are customary rules, so they are maybe weaker than others, but they are great tools for it. So I will maybe stop like this because I'm set to do it, and I will keep all the rest for the debate. I think, humanitarian law must remain action-oriented rather than sanction-driven and criminal-oriented, because otherwise it really loses its spirit and way of application. And that's it. I'll keep it the rest for you later. Thank you.
Thank you very much, Françoise. And indeed, we'll have more opportunities later. You will have more opportunities later to develop some of the points that you referred to during this presentation. Thank you very much. I realized before giving the floor to Hansjoerg that I forgot to mention to the small promotional announcement. You can find at the back of the room, there on the credenza, some flyers presenting the book, and with which you can get special offers if you order them online, I believe. So all those who intend to use this on daily basis, and even those who do not intend to use it on daily basis but are just interested, are very much encouraged to grab this flyer. And then there is also an article written by the executive director of MSF US, Sophie Delaunay, about something that Françoise referred to, the impact of counterterrorism measures on humanitarian action. And I think it's a good introduction to give the floor to Hansjoerg, because it's probably something that you will touch upon during your presentation. Hansjoerg, the floor is yours.
Thank you. I thought you didn't want me to touch upon this, but what I wanted to say, just picking up from where Jérémie left it on the book, and I had the pleasure of working with Françoise on a project that we're currently doing on arbitrary denial of access that I'll be speaking about in a second. But I highly recommend to you the book, not only for the lawyers, but also for its first 20 or 30 pages. Because it's a narrative of where IHL stands today, what the tensions are, what the opportunities are, and I really, it's almost reflective of where the humanitarian community overall stands, and it is a very, very good, I think, marriage of practical operational developments and the opportunities of the law. And there were three things from that, if you allow me to highlight this, that really stuck out. And I think there are three important caveats for our conversation. The first one was right at the beginning that IHL has become an essential element of international diplomacy. I mean, humanitarian diplomacy clearly, but even beyond this. If we look at, and recent examples are no exceptions or confirm this, if we look at the Security Council's practice, it does not only refer to IHL sort of somewhere in a caveat. Very often the discussions are about IHL and IHL enforcement, in fact, at its very center, whether that's around issues of mass atrocities and violence, protection of civilians, or access. It's become more than a reference point for humanitarian negotiators. It really is the test at some point, to a certain level, also for Security Council action. That, however, also highlights one of the tensions that you highlighted, not that we don't want the Council to do this, but about the potential repercussions for humanitarians. So on the one hand side, it's between this building acceptance, as you nicely put it, I think yesterday, building acceptance and promoting enforcement. And I think we all can recall a number of things where we believe the Council has done very, very good and right in just highlighting certain issues, and access right now is just one of the elements. But not all of us, protection of civilians, another one, but all of us get a little, particularly in the humanitarian community, a little anxious and shivery when it comes then to enforcement. And I remember resolution 1973 over Libya, where it was very, very good. All of us were sitting there and thinking, oh my God, I mean, protection of civilians, it really is a case of protection of civilians. What if they march on over to Benghazi and Breda and so on? And then the resolution came. But then a lot of us had lots of qualms over whether that should have also been used as the reason for military action then, you know. And so there was a lot of debate whether it was good that protection of civilians was in there, because then it gets enforced. So this tension, I think, is inherent in us ourselves. On the one hand, we want, and we've had a lot of discussion around more compliance, more enforcement of international law. On the other hand, there are also certain tensions and burdens that then come with that very enforcement. I'm not judging, I'm just highlighting a tension that is very difficult sometimes to reconcile. A second caveat is, and you put this, IHL, you explained this very well, IHL is not an ideal body of law. And I come from a civil law tradition, as many of you may come, and you know, we're sort of the very formalistic dumb lawyers over the more creative common lawyers who you know, can construe all sorts of things out of precedents. We need to read black on white what the law says, and so for some of us, IHL is less than satisfactory, because it resembles more a mathematical exercise of really knowing your law very, very well and piecing together different bits and pieces that are actually in different conventions and APs and customary law to actually get at an answer on an issue. So it's not as clear, and that's the complexity that you highlighted. But this being said, there's one area, and sort of all of us come from a, or have at least at some point worked in the humanitarian field, and what I've discovered over the last sort of 2 years is that while if you go to a bookstore and you go to the IHL section, you will find a lot of books on the law on armed conflict, but you will not find the standard book on the law of relief operations. There is far less work done on what do we mean by access. We use the word every single day, and we think we know what it means, but then if we go into a conversation, we actually figure out that we don't really know what it means. It's a very complex concept that as such is not even mentioned or elaborated in IHL. And that's what makes it so difficult, and I think we need to invest more into advancing or focusing less on whether the law is right or so on. It's more advance the interpretation of the law. Identify the right issues that we need to clarify, whether that's protected areas, protection of civilians, what a civilian means, what we mean by access, what we mean by arbitrary denial. Put that out there and put it to the test of the law. And you'll be surprised how many new and additional reference points, at least, not necessarily binding answers, but reference points you get. And the third caveat really is, I think one of the great achievements of the Geneva Conventions is that it has over all the rules of law that have existed way before the Geneva Conventions. You've added primarily through Common Article 3, but also the spirit that sort of pervades the entirety of the documents, an important right of civilians to receive assistance and protection. I think that's very important. That's when sometimes people say, where do you take this right from? It is the very essence and spirit of the Geneva Conventions, and that is an important contribution. Now, as you would have guessed already, when OCHA, and I will want to talk a few minutes about access specifically. For OCHA, in the field, on the ground, that is, in addition to promoting protection of civilians, ensuring coordination with others around these issues, access is a daily reality. Perhaps not as deep in the field as it would be for you, but more at the macro, at the political level with governments and so on. So we have, prompted by a number of recent developments, we said we want to understand access better. And we put together a group with Oxford University, but also MSF, operational agencies, other scholars, ICJ judges, and so on, to look at this a bit more deeply. And while I'm not going to bore you with legal details, just this much. The first element that we need to understand, apart from the distinction between international and non-international armed conflict, and that the rules are rather different, or the explicitness and the complexity in terms of access. But as I said, access as such is not really elaborated. What the law talks about is consent to impartial relief operations, in a way. And this word of consent, we need to understand a bit better. What do we mean by consent? Whose consent is required? What if consent is given to operate in some part of the country but not other parts of the country? So there is, even in the word consent, there are numerous challenges that the law doesn't answer, but that we might be able to answer by comparing and putting together rules of customary law and the different conventions. The most important aspect for us is that for years we've been putting to the council, we've been putting to governments, we've putting to parties to the conflict, you have to grant us access. And we go back and we negotiate again. And that will continue to be our primary activity in the field. But we also have now started to ask that second question: what if that doesn't lead to anything? Is there a point at which that behavior becomes arbitrary? Are there consequences? Which leads us also partly back to the tension at the very beginning. Are there consequences to consistently denying access? And I'm not talking about military intervention or courts or something, but within the law. Does the law not foresee that someone says no and something is then arbitrary? So we've looked actually much more at this issue of arbitrariness, and we think we got a lot out of this this exercise. We have a paper ready that goes into the details of cross-border operations and looks at the issue of arbitrary denial of access, and we're further elaborating this, and it goes into some situations where you have valid reasons for not granting access, if there is temporarily some combat action in that area, But that doesn't mean for 2 years you cannot say no one can go there. But looking at some of those, what constitutes arbitrariness, let me give you perhaps, and then I'll close with that, a few examples. First of all, and most importantly, we've looked at some of the commodities that IHL, throughout the 4 conventions and the additional protocols, actually privileges, sort of a set of privileged commodities. And if you read the entire spirit and letter of the law, it becomes very clear that what the wisdom of all these states that negotiated and signed the treaties had in mind is that for commodities such as food, drinkable water, other items indispensable for survival in particular circumstances, for example, blankets, shelter materials, particularly where populations face starvation, but also medical supplies, including life-saving and life-prolonging medicines and vaccines, equipment for the wounded and sick, and there are a few others, that it's assumed that there are no reasons for withholding, that there is consent that needs to be given to go ahead. So withholding, if there is need, withholding these items constitutes arbitrariness, constitutes arbitrary denial. In addition to that, there are a number of cases like withholding consent in situations where the civilian population is facing starvation, withholding consent of medical relief operations where it's presumed that this affords an advantage to the enemy, selective withholding of consent with the intent of inflicting discrimination against one part of a group, and so on and so forth. I could continue. So what I'm trying to highlight through this is the fact that you go to your law section, you open the bookshelf, and you don't have that law on relief operations, and you open that book that exists on the law of war, and it only has very little on access, doesn't mean that the Geneva Conventions and its additional protocols and customary law doesn't give you an answer to all those questions of access. We just need to invest more into the research and the legal research and discussions around the practical issues and challenges that we see every day to elaborate against the reference points and legal background of the conventions some of the legal answers that the law is able to give us. Thank you.
Thank you very much, Hansjoerg. And I will now, without any delay, give the floor to Gabor, who I think will develop a bit more this aspect mentioned by Françoise about how humanitarian law went somehow backward with some actors trying to bend the rules of international law in the last decade, particularly indeed in the context of the global war on terror. Gabor, the floor is yours.
Thank you, Jérémie. Yes, I will pick up on the invitation to discuss, as Françoise mentioned, that the global war on terror has in fact dramatically weakened IHL. But my focus will not be on the sufficiency of the law itself. I think it's fairly clear to all of us at the table, perhaps most of us in the room, that there's much more of a problem in the implementation of IHL having to do with all of its aspects, including humanitarian concerns, than there is with the content of the law itself. And the problems of implementation, at least in connection with the experience of the last decade plus since 9/11/2001, I think does in fact have to do with the manipulation of the law and legal interpretation by perhaps the most influential player in the field, which is of course the United States. I want to make 5 points in connection with this. The first 2 points are contextual. The first point is that civilian protection actually is a relatively new concept in the realm of IHL. The first Geneva Convention of 1863 was not about civilians at all. It was rather about protection and assistance to fallen soldiers in the field. And as far as international treaty law is concerned, the Geneva Conventions, the protection of civilians did not enter into the treaty category until 1949. That's the Fourth Geneva Convention, which covers the realm of civilians as protected persons under humanitarian law. And that was the consequence of the experience of civilians in the Second World War. Now, the legacy of emphasis on civilians is short, but the legacy on emphasis of protection of forces, as represented in the First Geneva Convention, is rather longer. And this distinction between force protection and civilian protection is magnified by experiences on opposite sides of the Atlantic Ocean. The U.S. experiences war in a very different way than much of the rest of the world. Much of the rest of the world experiences war in large part through the effects of conflict on their civilian populations. The U.S. does not have wars on U.S. soil. And so the focus from the U.S. perspective on the law of war, on the law of armed conflict, on international humanitarian law, they all mean the same thing, is not so much about civilian protection, it's about force protection. How do the U.S. armed forces protect themselves? And this is a very different perspective than the one that prevails in much of the rest of the world. In contemporary conflicts in particular, it's not merely that civilians are increasingly the collateral damage of war. Civilians are increasingly the target of armed conflict. But that's not so much the case in the experience of the United States. Obviously, the attacks of 9/11, if you construe them to be part of armed conflict, are an exception to that. But look how exceptional that experience of 9/11 actually was to the experience of the United States. Now, I teach humanitarian law at Columbia Law School. I've been doing it for about 6 years now. I have usually a good number of international students and a good number of American students. And I can see day to day in all of the topics we discuss how different the perspectives are between, on the one hand, those that come from the experience of an American background in law and in discussing issues having to do with armed conflict, as opposed to not just Europeans, but those that come from other countries as well, particularly the countries in which individuals have personal experience with war. It's in this context that I think we need to understand the liberties that the United States took with IHL in response to 9/11. And while we, the United States, have retreated from some of the more egregiously flawed interpretations of IHL that prevailed in the aftermath of 9/11, there's actually more that remains the same than has changed in the transition from Bush to Obama administrations. So torture, secret detention, those have all been rejected, were rejected very early on by President Obama, in fact, with executive orders in his first or second full day in office. But overly broad targeting practices, overly broad detention, and unfair military trials continue. And they continue predicated on claims of military necessity and that this is all contained within the scope of armed conflict. These policies, for example, targeting, they not only adversely impact people who are clearly civilians, in other words, designated as collateral damage, not the intended targets of attacks, but as collateral damage of attacks. But they also sweep civilians very falsely into an overbroad definition of combatant in targeting, in detention, in trial. And this is something that Françoise was discussing as well. The destruction of the boundaries between what is war, what is not war, the destruction of the boundaries between what is a combatant, what is a civilian, these are all liberties that the United States took in its overreaction in the aftermath of 9/11. As I say, we're slowly trying to recover from those overreactions, but there is more that still needs to be done to recover than that has been done. Why am I focusing so much on the United States? Obviously, the United States is far, 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 far from the worst actor when it comes to violations of humanitarian law. But there are a couple of reasons that the United States is extremely important. First, we, Americans, we pray at the altar of the rule of law. And that's by and large a good thing, because without law, there is obviously a legal vacuum, and that's intolerable. But it does cause us to bend the law rather than to merely ignore it. So, if the Lord's Resistance Army denies that it's killing civilians, that does no harm to IHL. In fact, that reinforces IHL. It is an indication that there is a recognition, even on the part of Joseph Kony, say, that it is unlawful to kill civilians in armed conflict. Denying the facts is one thing, but bending the law is something else. And when we bend the law, we not only adversely influence the ability of the law to function in the specific context we're talking about, but being the United States, I think it's fair to say that where we lead, Joseph Kony and others may well follow. And I'm not just talking about non-state actors, but states as well. The United States has a very significant influence on what the rest of the world considers to be the law. Finally, I want to mention one aspect of U.S. law and practice that has had a most direct effect on the ability of humanitarian actors to operate. And that is one aspect of the law that has developed to counter terrorism, and that is what we call our material support law. So as you may know, it's a violation of U.S. law to provide material support either to designated terrorists, they're on a list maintained, say, by the Treasury Department, or to people who you knew were engaged in terrorist activity, even if they're not on that list. Now, you may assume that this legal prohibition is focused on Americans, or is focused on things that people do in the United States. But that's not true. The United States exercises a very long arm of jurisdiction. It establishes for itself and asserts this jurisdiction globally. It establishes and asserts this jurisdiction not just as to American citizens, but to anyone. So if you are a humanitarian actor, and if it so happens that there's a roadblock at which you have to, let a carton of food fall off the truck as the price for going across to deliver the rest of what you've got in the truck, and if the individuals manning that roadblock are either on the terrorist lists or you knew or should have known that they're engaged in terrorism, then you can be prosecuted by the United States. Whether or not you ever intended to help terrorists or terrorism, you can be prosecuted by the United States. There's a huge imbalance in the attempt of the United States to take reasonable precautions to prevent the proliferation of terrorism, and on the other hand, the essence, the need, the importance of competent humanitarian action in the places where it's needed. U.S. law does not recognize the struggle between these two imperatives. It simply says, you may not do that. And it will exercise its criminal jurisdiction against those who do allow a box of food to fall off the truck, whether they're American citizens, and no matter where they may be operating. This law has an incredibly strong, chilling effect on the ability of humanitarians to perform humanitarian action. Let me conclude with 3 observations that are in response to the question that Jérémie posed in the first place. Well, first, I agree. There is no third category of conflict or of persons. There is armed conflict and non-armed conflict. For armed conflict, there's international armed conflict and non-international armed conflict. In armed conflict, there are combatants and there are civilians, and the law is clear on that. And any attempts to create third categories are only attempts to actually evade the law. Second, IHL is not too loose, but states have to implement it. They have to implement it in their military manuals, in their statutes, by codifying war crimes, and then they have to enforce those statutes. They can't rely on international bodies. They can't rely on the International Criminal Court. Third, IHL is not too complex. It is complex, but it is not too complex. And the idea of trying to amass all of the concepts and rules of IHL and put them into the head of, say, the fighter in the field is really a mistaken notion in the first place. Some of the obligations of IHL are for legislatures. IHL requires that parties to the Geneva Conventions implement the rules of the conventions into their national law. Some of the obligations are for military lawyers to make decisions about the application of IHL in specific contextual situations. Some of the aspects of IHL are for military commanders to tell their troops what to do. And then only in the final analysis, there are aspects of IHL that are up to the soldier in the field and even the member of the non-state armed group to implement. And as far as those non-state armed groups are concerned, yes, there has to be engagement with them in order to see that they are aware of and responsible for complying with their IHL obligations. That's why we need engagement with non-state armed groups from organizations like Médecins Sans Frontières and another organization that I happen to think very highly of called Geneva Call. Their purpose is to engage with non-state armed groups in order to educate them on their IHL obligations. So, final analysis, it's not gaps in IHL, it's not problems in the content of IHL, it is the lack of will to implement it and to enforce it that I think is the great struggle that we need to undertake in order to make IHL of continuing relevance in conflicts going forward. Thank you.
Thank you very much, Gabor. On these final remarks, I had a couple of questions that I would have liked to ask to the panelists, but given that time is running and you all went a bit beyond the 8 minutes imparted, but for our great pleasure, I mean, those were all very interesting presentations and interesting remarks. I will go straight to the floor. Take your questions, and then I might have an opportunity to squeeze in my own questions in the process. Before that, 2 or 3 housekeeping remarks. First, please mention your name and affiliation when you take the floor. Secondly, I would appreciate if you could stand up so that people can see you. Some of you might be shy and prefer to stay seated. It's also a possibility. But please, in any case, keep the microphone steady in front of you in order to ensure the good recording, since this event is webcasted live, and if we want the watchers behind our computers to hear your questions, please keep it steady in front of you. So, on these words, the floor is yours. I see one question at the back, and if fine with our panelists, I suggest that we take 2 or 3 questions at once, and then we'll go back to the panel. Jake.
Thanks very much. I'm Jake Goodman from Crisis Action. I wanted to pick up on the point on arbitrary denial of access. And can you talk a little bit more, any of the panelists really, on 2 things. First, how that designation is made, and who's responsible for sort of deciding that there's been an arbitrary denial of access in an operational way in the field, how you see that working. And then secondarily, what the implications are of it, again, from an operational perspective. And I'm thinking here, of course, of Syria, where Valerie Amos, in her last briefing to the Council and then in remarks to the press after, mentioned that denials were, quote, arbitrary and unjustified. So the implications of that in your view?
Thank you very much, Jake. Any other question in the room? If not, then I will seize this opportunity to ask one of my own questions. From what we heard from each of you, it is clear that, well, it seems that IHL remains very much relevant to today's conflict and wasn't so much challenged by some would call the changing nature of violence or the changing nature of armed actors. Nonetheless, do you see some areas of international humanitarian law beyond maybe arbitrary denial of consent on the humanitarian access issues that would require further development? And I'm thinking here, for instance, about the development of new weapon technologies, drones, robot technologies. So please, your thoughts on this. And if somebody has a burning question, I can still take it. If not, we'll get back to the panelists, starting with you, Françoise.
Okay. On this issue of consent and access, I mean, I will carry out the perspective of non-governmental humanitarian organization, which is a little bit different from a governmental or an intergovernmental organization. To make it simple, because it's the way to proceed, MSF considered that in Syria, we've made request to the government for access. So it's not because we call Doctors Without Borders that we do not recognize that we are crossing borders. So we make requests. When the requests are either not answered, because they may not be denied, states and other, everyone who has a lawyer knows that it's better not to answer rather than to answer no. So when our requests are not answered, then we act. And either we can act through cross-line, which is a usual means, or we act through borders. But what is very important to know is that the main action and the main driver of the action are the needs. We assess the needs. If others, government or non-state actors, say there are no needs, then we discuss on fact. When we cannot access an area with the agreement of the people, holding the checkpoint, the border, the cross line, we go through a route where people authorize us. What is very important to understand that MSF doesn't act against the will. We're not that strong. We don't act against the will and the consent of everyone, but we find people that allows us to do. And then going back to the case of northern Syria. In northern Syria, we think that going into an area where needs are massively present, without the authorization of the government, but with the authorization of the de facto authority in control of this area, is fair enough regarding international humanitarian law. Because it opened the whole debate that we barely mentioned of the non-state actors. And obviously, in non-international armed conflict, only one party to the conflict is a state. The second one is, or the third, because there may be many parties to the conflict, the others are non-state. And the question is whether or not parties to the conflict are entitled to allow humanitarian action in the territory under their control. For MSF, it is a perfectly fair interpretation of international humanitarian law to say that non-state actors are allowed to consent to humanitarian action in the territory under their control. Otherwise, it would be very perverse because we held them responsible for what happened to the population under their control. They are already criminalized as terrorists or whatever. MSF is already falling under, the criminalization of other, but United States are only one party to the global situation where we are working. And in fact, as humanitarian actor, we are very often criminals, at least for 1, 2, 3, 4 parties. But these are risks that needs to be taken, because you cannot be the friend of everyone. And this is why humanitarian law must prevail on domestic law. The day it goes in front of court, of American court, we will be happy. But the main risk our teams are taking every day are security risk. And the legal department take care of the legal risks. And we will be very happy one day to deal only with legal risk, while every day we're dealing with security and physical danger that is not only the one of humanitarian actors. Again, I want to make it clear that the fate of humanitarian actors is the same and as the one of the civilians. So we are not the victim, they are. And the question about improvement of law. As we all say and agree, law is already quite comprehensive. There's one, I would say, a caveat. But as a lawyer, I know that it's better to have bad law than a good law that will close everything. And this, for instance, is why international humanitarian law has been wise enough not to write definitions, because if you write a definition, you open, the area for debates. So we have to make sure that we do not create things that are worse than what they are today. This is really important, because in a democratic country, in a country driven by the rule of law, everyone thinks that law is the solution. Very often, law is the problem. And in humanitarian activities, the real deficit is about action. We could have perfect law, perfect humanitarian consensus. Today in South Sudan, in Central African Republic, the people are not suffering because of lack of law, but they are suffering because of lack of assistance. Who are the humanitarian organization? This is a parenthesis as I close. But Protocol 2 it has been written by states, and the law of non-international armed conflict has been written by states. So obviously, there is a kind of conflict of interest, I would say, as lawyers. And where everywhere in the law of armed conflict, law refers to parties to the conflict, because it is what matters. The ones who are fighting have responsibilities. So the humanitarian law put pressure and emphasis on the parties to the conflict. But regarding the consent issue, Protocol 2 refers to the government. And it does not refer, while for other issues, like, for instance, Article 3 Common, that also applies in non-international armed conflict, it does not refer to consent, and it refers to parties to the conflict, putting on the same stand non-state actor and the state actors. Protocol 2 gives a sort of legal asymmetry to the state, which is something that should be a matter of interpretation in the global spirit of the law rather than rewriting. And the whole issue of the arbitrary withdrawal of consent is really about that, putting the state as a party to the conflict and not allowing the state to play both cards. I am the state, I am the government, and I'm also fighting with all rules of law, including domestic law, that make the other party criminal, terrorist, and whatever. And this is, the question of the abuse of domestic law by government during armed conflict is really crucial. And MSF, we are faced with questions such as forced entry in hospital to get the record of the wounded, which would be allowed in time of peace, but which is forbidden in time of law, not forbidden completely written, but we fight against this, arguing on Article 3 Common, the respect of medical ethics, and also the safety of the medical space. Thank you.
Hansjoerg, do you want maybe to react to the question on arbitrary denial and the issue of consent?
No, look, I mean, I very much agree with François' last point. The whole point is to take what we've been doing forever, and I'm not saying that we have to give up negotiating access, and now we immediately move to discussing arbitrariness. I think it's very clear and needs to be emphasized that what humanitarians do is first and foremost negotiate. We go and sit with all parties, we talk to all parties, we need to look at all practical arrangements and so on. That's still the primacy. But we need to also do the second step and say it cannot be that we sort of fall back into the pre-Geneva Convention time where it's almost seen as it's the sovereign who decides a thumb up or thumb down. And I think that has changed with the Geneva Conventions. There are a number of caveats in there that make it relatively clear that, in fact, the onus or the burden of proof is reversed. You know, it's on the state or the party to actually make clear that there is a valid reason for withholding. We don't have to prove that they act arbitrarily or something, like, or that we have a case to make. Yes, this is all against the overall background of assumed need. So if someone challenges, as you said earlier, the fact, you know, listen, there are no people in need, so we don't think you need to go there, then you probably have to work a little harder to make the need known. But I don't think what we're arguing for right now is to say we need to exactly know every single person in a given context. So you referred to Syria. If we look at Aleppo, we don't need to go to the depth of having a needs assessment and profile for every single person. I mean, think globally, and no one has disputed this, not even in the Security Council, that there are needs, manifest needs of people. So if we have that logic, then let's look at what some of these needs are. And if it is food and water and means for survival, then the law, again, is relatively clear. The assumption is you have to. It's not a negotiation. It's not about valid grounds. It's an obligation to let relief operations go. And in that instance, it doesn't make a difference whether that's an international organization or an NGO. However, where cross-border in particular, there is a blockage, it makes a huge difference. Because member states, and by extension, a member state-based organization like the United Nations is arguably bound by the rules of international humanitarian law. So we don't have all the same freedom and liberties as much as we, not only in spirit, but also in other ways, support what NGOs are doing. So it is really about, so this burden of proof, so this reversal of the onus, you also change the dynamics of the conversation. You change the dynamics of the conversation as reference points on the ground, where people can say, look, you need to realize what you're doing is not just sovereignty in or out. It actually is against a set of privileged commodities. It's an arbitrary behavior. However you phrase that in the situation, diplomatically or appropriately, it changes the reference point. It changes the conversation. It does change, in my view, will allow to change the conversation, including in the Security Council across the street, away from talking about us, the organization, which very often the conversation is about. It's about access for an organization. So why does OCHA need access? Why does this organization need access? Whereas the arbitrary denial actually prism will shift the focus onto the impact that the denial has onto the people in need. It forces us and everyone else to look much more carefully why this is arbitrary. It's arbitrary because it costs people's lives. It prolongs suffering. So the prism there is no longer the discussion over the organization and whether that's the right organization. It's actually over the right needs, and the need, that's why the obligation to let people go. And it's the same thing also for third parties. I mean, let's just put that in. It's not only between parties to the conflict, it is also neighboring countries that need to give their consent to letting relief operations go through their, across their borders into a territory. So there are also situations where they need to be counted in. Now, on the consequences, let me just be very clear. This is a conversation as a reference point. We're not making a case or intending to make a case for military intervention or so that access, humanitarian access, is all of a sudden enforced by a military force. That's not what we're saying. But what we're saying is there need to be consequences to this. And ultimately, I have to tell you, IHL over the last 20 years has benefited a lot from, and in its meaning, from some of the judgments and rulings of courts. And I believe once a court, an international court, has also looked at instances of arbitrary denial of access and the human cost that this has had, it will be a game changer. I myself, and I'll end on this note, I was less than 20 years ago a member of a commission of experts in Bosnia-Herzegovina, and I was part of the team that focused on the violence and the crimes that were committed in Prijedor in northern Bosnia. And the purpose of this commission was, there was no ICTY. There was not even a thought that we would ever have an ICTY. It was to collect evidence in case there ever was an international court that cared, to determine for the first time ever that there was a case of genocide conducted. 20 years, less than 20 years later, we take this as a given. That's what international courts do. They look at war crimes, genocide, crimes against humanity, and determine this. This is how far we have come, partly because of this interplay between international jurisdiction and jurisprudence and IHL. But in the first instance, what we want to achieve through this arbitrary denial lens is shifting the dynamics of the conversation away from, and I do believe there is a difference between saying, sorry, sovereignty, you cannot go across a border, from saying, this is a case of arbitrary denial, this costs so and so many people's lives, these are the consequences, and if you condone this, or you stand by silently or idly, you become complicit in the continued suffering and dying of those people. And that's what this arbitrary denial clause is going to do.
Thank you, Hansjoerg. Gabor, I wonder if you want to react to some of Hansjoerg's remark, or otherwise just to focus on this issue of gaps, and are there still gaps for development in IHL?
Well, you mentioned the question of new technologies, and I want to address that. I also just want to react to one thing that you said, Francois, about how you at MSF, you're all criminals under U.S. law, and I believe that that's probably true, yes. Now, if I also understood you correctly to say, but you would welcome an opportunity to present, say, in a U.S. court, this struggle between U.S. counterterrorism law and the imperatives of international humanitarian action. I'm afraid I would not want to have to bet in your favor, because I think that case has already been argued in U.S. courts and came out badly, and that's the Holder versus Humanitarian Law Project division, in which the United States Supreme Court made quite clear that the imperatives of humanitarian action, and even to the extent that they may be ensconced in international law, are no match for the will of Congress, which decided that it is a crime to provide material support to terrorists. So I wouldn't be optimistic about that, unfortunately. As far as new technologies are concerned, and particularly in relationship to the continued vitality of IHL. Well, it just so happens that IHL does address the development of new technologies. Additional Protocol 1 has provisions requiring states parties to analyze new technological developments in relationship to their possible and probable effect on the ability of states to comply with the principle of distinction, that is, distinguishing between military objectives and civilian objects, distinguishing between combatants and civilians. And it also obliges parties to armed conflict to do that analysis in respect of what's called the principle of proportionality. Even if a weapon is logically capable of targeting civilians, is it likely to result in excessive civilian harm? And these are all analyses that parties to the protocol are required to do in advance of deployment and during the conceptual phases of considering new weapons technologies. This, I believe, is not just limited in application to parties to the additional protocol. I believe this is, for the most part, considered to be an aspect of customary international humanitarian law as well. Now, as far as drones are concerned, just want to say one thing in particular. I want to distinguish drones from autonomous weapons. They're not the same thing. There's a human in the loop. There are lots of humans in the loop in the deployment of drones. Generally, there are something like 150 or so people involved in an actual drone attack. Autonomous weapons, on the other hand, which are now just a thought process, they don't exist, but they are certainly under development, would take humans completely out of the loop. And that would be a game changer as far as the technology of war is concerned. There are issues that are unique to drones. For example, if a drone can loiter, as it is said, over an area for a long period of time, the proponents of drones say, well, that gives us, who are operating them, an opportunity to be more discriminating. We can see more. We're not required to just react as of the moment. And they also say that the fact that there's no pilot in that drone means that we don't have to take targeting decisions on the basis of fear that the pilot will be harmed. So the argument is it creates better protections. On the other hand, if there's no possibility that the operator can be harmed, the use of a drone may make it more likely that it will be used, and in a broader sense. So there are pros and cons in connection with drones that have to do with the difference between drone and other technology, but you can also launch a cruise missile from a submarine without any potential harm to the operators. So it's not that new. What's really new, though, will be this distinction between drones and what I'm afraid is the future, and that is completely autonomous weapons.
Just a word, because I am a lawyer. I've never admitted that MSF was a criminal. Just to be clear, the anti-terrorist law legislation in the US has cousin everywhere on earth. We have the Australian, but we also have the Syrian, we have the Turkish. So we have to cope, and we do cope with all those anti-terrorist regulations that are mostly copy and paste of one each other. The only thing that differs is who is a terrorist. This is the problem. It's changed. By the time you cross the border, terrorist has changed. So there's something in international humanitarian law which enable humanitarian organizations to cope with this problem, which is an old problem, which is the duty to remain neutral and impartial and not make sure that your relief do not constitute or don't contribute a military gain for one or the other party to the conflict. So we have internally very strict rules that enable us to argue. I'm not a judge, but if one day we're sued, and we are accused very often, not in court, but we are accused very often, and we have element to argue taken from our practice, from our own internal doctrine, regulation, that are pre-existing anti-terrorist rule, which is obviously leaded to do we contribute or not to the military effort of any one group involved. Thank you.
I think Hansjoerg wanted to
just on the
react to it as well.
counterterrorism issue, I cannot withhold. Half a year ago, or 7 or 8 months ago, we launched a study here in this very place with Jan Negeland and Kyung-Hwa Kang from OCHA, that OCHA and NRC did, that's sort of called the impact of counterterrorism measures. And I think Gabor was not only part of that, but also at the inception when he was with OCHA. And there's some interesting findings, but basically what it says, one of the key things is it's not the laws, none of the laws of, I forgot now, 10 or 12, Jeannick, how many? 15 major donors that we looked at. None of the laws actually prohibits engagement of humanitarians with listed or designated organizations on terrorism list or whatever it is. But, so it's not the law, but it's the policies very often. So it's the policies that have a chilling effect. And it's the fact that a group is being designated in a particular area, that when that happens, it has such a chilling effect that everyone self-censors themselves. The humanitarian organizations, but also donors. They say, well, you know, that's more okay. It gets into clauses, very difficult clauses, and so on funding and so on. And so, just to say, for those of you who want to know more about this, I mean, we did quite an elaborate study on this. And a last comment is on the intention. What we also found is that actually in the criminal laws of some of those 15 donor countries, there are considerable differences. And you have a number of countries where it's clearly spelled out in the law. And again, those are civil law countries primarily, where it's very clear that you need to have a very specific intent to support with your action that very terrorist organization and its terrorist conduct. So what you described cannot really happen, doesn't really cause as easily criminal liability in those contexts. But what does, and there are a few others, more so in common law contexts, that actually allow a much more indirect, through knowledge of, may contribute, a much more indirect way of supporting. And that's, again, an example where the law matters. But I think the overall concern for us on the humanitarian side, we found with some of these clauses, is not the law, it's the policies primarily. Thanks.
Thanks, Hansjoerg. We have, 6 minutes to go, so if there is somebody having like a burning question, I'm happy to take it. And yes, there is one. And I'm afraid I do not see any other hands, so I think this will be the last question. Then we'll turn back to the panelists all right, so we have 2 questions, very brief questions, please go straight to the point, and then we'll turn back to our panelists for a final remark, an answer to the questions. This gentleman first, do we have a mic? Oh, a mic, or can you please? Yeah, but can you wait for the mic, please, 1 second? Thank you.
Hello, my name is Manoj. I am from the Office of Military Affairs. My question, in fact, it was a view that I'm going to take from Mr. Rona. This was regarding the role of UN peacekeepers as far as IHL is concerned. You know, there is no doubt that it is applicable to them, but the problem comes again on the implementation and, more importantly, the enforcement aspect of it. Because there are so many actors. I mean, UN does not have control over the actions against them, especially criminal liability. So, do you have any suggestions to improve the implementation and enforcement aspects regarding following of IHL by UN peacekeepers? That's all my question is.
I can answer that very quickly, so let me do it. 1999 Secretary General's guidance on the applicability of humanitarian law is much too limited, much too general. We need something new.
That's exactly why I asked this question. I know about it.
All right. Then maybe, Hansjoerg, or you want to react, but we'll take the second question first, and then we'll wrap up. Thank you for your question.
Hi, Christelle from the IIC Secretariat. My question to the panelists is, what would you do to try to get access to South Kordofan and Blue Nile, where 800,000 people have been inaccessible for 3 years? Thank you.
Thank you very much for the brevity of your remark. Of your question, sorry. So before turning back to the panelists, I would like to ask you if you can, within like 2 or 3 minutes remarks, in order to finish by within the time. Can you tell us a word about the universality of international humanitarian law, and maybe the fact that it is contested, that it might be contested in some quarters, particularly within some non-state armed groups that, as you mentioned it before, and it's an area that we didn't discuss enough maybe, but some armed groups that did not participate to the construction, to the elaboration of international humanitarian law, and whether we can relate if we want to get into the action and not the sanction or the prosecution, as you mentioned, Françoise, if we want to relate to them and that international humanitarian law relate to them, are there efforts that should be done in order to really adapt humanitarian law to their own normative framework, whatever it is, within a Sharia law framework or within Buddhism tradition or whatever? So I let you address the last question and maybe a remark or your thoughts on this last point, which is not an easy one.
Okay, maybe just one comment about, South Kordofan, I will let the other comment. MSF is doing it utmost. We will do cross-border, we will do what we are able to do. One of the issues is also about the means, because we are confronted to a number of situations where the needs are tremendous, and we need all to have more actors involved. It is also part of acceptance. Your efficiency, your added value in the field is part of your acceptance. In every country, we find that actors, local players, but they are with a militia government, they look at the humanitarian circus in a way that do not favor the acceptance, in the sense that if we are really efficient, able to deploy and so on, we open and we create also part of the space we claim to have. So efficiency is the sort of, entry point also for a humanitarian organization. Prove that you are able and capable of doing something and doing what you pretend to do. Just another issue. To stick to the legal part, I think the non-state home group, non-state actor is a key one. And maybe to be provocative and to be dynamic, to reverse the process, I would say that non-state actors don't have so much trouble understanding what IHL is about. And to take maybe Gabor remarks, IHL is a big body of law. We always start with the basics, the minimum, and for MSF it's easy, put brackets, because we start with the core, medical mission, and as you mentioned, medical care was the first Geneva Convention. It was for wounded, for combatant, but this is the beginning. It's very practical, it's professional, very practical. So you always start with something concrete, and then you enlarge, you elaborate. You have to get your feet on the ground first, and then find someone to discuss with. And when you're able to find something useful to do, it's even with Islamic or terrorist group, whoever, remember northern Mali, we managed to find common grounds. Because Sharia law does not disregard medical mission. Has something with corporal punishment, but we are in a country where death penalty is still applied, so it's kind of corporal punishment as well. So we find ways, and there's no need to translate humanitarian law into all kind of, I would say, ethnic or cultural or religious languages. We are speaking about basic human needs, basic humanity principles that are understood by everyone, I can guess. But the problem is more with the strong player, the strong actor. And we, as MSF, sometimes we have more difficulties with states than with non-states. It's somehow better to put it on the table rather than say, okay, we have to educate non-state actors. They have nothing to gain in abiding by humanitarian law today. They are criminal by the very moment they took up arms in their countries. And they can be more criminal if they don't allow humanitarian activities, but they are criminal per se. So they have nothing to gain in applying humanitarian law. Still, they do apply a number of things. So this is, I think, very important to remind that states are often the one that knows perfectly well humanitarian law, but still use humanitarian issue as an additional weapon to control, terrorize, weaken the adversary, disregarding the fate of the population, which is still theirs.
Hansjoerg, do you want to
And I'll
make
just
a very
be
final remark?
Very brief. I'm not. We have many more internal OCHA opportunities to discuss this, and I could refer to the operations director to get the question answered. But in a more serious manner, I don't think that anyone is suggesting that IHL. You show someone in the government or the party the law, and then they say, "Oh my God, I didn't know that," and then you open up. Obviously, that's not the case. And in my very first posting in Bosnia, I remember the first time I met the ICRC person who said, "Look, the first thing you do when you come to the field, look one last time at your Geneva Convention, you take the bottom drawer, put it in, and then you get going." And I think that's still what applies. It's unfortunately negotiating these things is manual labor, and it's exactly as you said, finding common ground, finding practical arrangements, and so on. It's a tedious effort, and particularly very unthankful for those 800,000 and more people in other places. But I think we've all agreed that the alternative should not or should only be in the most exceptional circumstances to enforce access, humanitarian access by other means. But I do believe that a Security Council highlighting the fact that access is arbitrarily withheld does also, or would also, have an impact on those with leverage over those parties. You can that. It gives you an additional reference point. I think that's what we're trying to say. I don't think that anyone is suggesting that this is a solution for all kinds. If I can just make one more observation, because it struck me when we spoke, and I think it's important to say that also in terms of the value of the law today. I mean, if you look at some of the provisions, you refer to Common Article 3.2, and that's what you refer to. But you also know that others would then say, well, but there is an AP 2, and though that hasn't been signed by everyone, there's customary law around that Article 18, Additional Protocol 2, and that has far more restrictions. What you can actually see is that the spirit and the willingness of member states that prevailed in 49 to really say civilians need to be protected, blah, 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 had tremendously eroded by 1977. And some of the discussions actually around in internal armed conflict and Article 18, the discussion was all about humanitarian assistance. If it was delivered based on Common Article 3.2, it would support rebellions and aid the enemy and so on. A lot of these arguments that we've heard. So the narrative had already changed within just those 30 years because the realities had changed. In 1949, the reality was the Second World War. It was really clear 60 million people later, people had gotten it. But the reality of what we have today, internal armed conflict, was not predominant. So people were more generous. By 1977, that was already much more of a reality. And you can imagine if we had to negotiate or someone had to negotiate these things today, you would probably get 50% of what is in the Geneva Conventions and so on. So we are, in a way, even the customary law rules. It's very difficult, almost impossible at this point to expand on those, and I think that's a political reality. And that's why the only thing that we can do is interpret better, make clearer. And I still have to highlight what Gabor said. I completely subscribe to. The law is very, very clear, particularly the law on armed conflict. But as far as we have an understanding of what I call the law of relief operations, those parts in the law that actually pertain to relief operations, we have a far underdeveloped understanding. And I think developing that understanding doesn't cost us anything, is in fact a responsibility we should all come together around, and it will help us actually make some of those arguments that the law is somewhere in a hidden way already contains much more crisply to parties to the conflict.
Gabor, your final thoughts?
I'm fine.
No final thoughts, you're fine. So The good news is that we have an answer to our original question. Yes, I think humanitarian law is still fit for purpose, but we have a long way to go to have it respected and implemented on the ground. So we all have to roll up our sleeves, and good luck. It's maybe achievable. Thank you very much for being here. Thank you to our panelists, and thanks.